Hello, my name is Claire Murray and I am Managing Partner of Specialist Employment, Partnership and Regulatory firm CM Murray. And I'm delighted to be joined today by our co-head of our partnership team, Zulon Begum. So we're here today to do two things. Firstly, to talk about those parts of your LLP agreement that you as a professional services firm should be thinking about updating in the current market. And secondly, to tell you about our new online GC tool called CheckYourLLPAgreement. So Zulon, why should firms care about their LLP agreements in the current market?
Firstly, I'd say, I always believe this to be true, that LLP agreements, partnership deeds, really are living documents, and they do need to evolve with any business and partnership. And that's why you need to constantly review them to ensure that they are up to date and in keeping with the firm's current structure, its size, the nature of its business, its strategic ambitions. So doing that periodically, I believe it's like, financial hygiene, which is necessary for running a good business. So making sure you're doing that governance hygiene bit is also really important, because otherwise you could end up with some gaps in protections, inability to make decisions in a nimble way, just because your firm is too large and the decision-making thresholds might be too high. So you just have to constantly keep that in review to make sure that your governance is appropriate for the business that you're currently running.
So what are the key provisions at the moment in the current market where we're seeing firms having to sort of pivot financially, sort of for cash purposes? We're seeing them trying to pick up strategic options quickly, opportunities quickly, and also deal with behavioural issues in a sort of a streamlined, consistent way.
The fundamental one would, of course, be that decision-making structure and process. If you're finding that actually decision-making has become bogged down because of the lengthy processes that you have within the business, you probably need to rethink your governance structure and the way you make decisions, and think about whether certain decisions should be delegated to office holders or committees or a board. And also whether some of your thresholds might be a bit too high, whether your process might be too lengthy to make that agile decision-making that often you have to make when you have usually some kind of threat to the business. So that it might be a partner is accused of serious misconduct and you need to suspend them, and then realize actually you need to call a partner meeting to do that. That's not really going to help the business deal with that matter appropriately. The other kind of issues where you might need to ensure that decision making is, again, nimble, is if you have those strategic opportunities on the table where for a merger or a potential investment into the business, if you have a requirement to have unanimity or even say 90% in order to pass that decision, then making those kind of strategic moves becomes almost impossible because the threshold is so high. So keeping that under review so that you can take advantage of those opportunities when they arise are really key.
Two things that I find really frustrating when you're looking at a partnership agreement, you might be advising a law firm or another professional services firm, is when it's a behavioural issue you're dealing with and you look at the partnership agreement and the partner duties are so generic that it's really hard to sort of find something specific that they're potentially breaching. Like, for example, don't breach bullying and harassment rules, for example. Nothing as specific as that. And then, so you have generic obligations, and then you look to the expulsion provisions, and it'll say grounds of expulsion for breaching the partnership obligations. And it's like, well, you just didn't say what the partnership obligations were in the first place. So that's a big sort of bugbear for me. And the other one is taking legal advice, the ability for senior management to take confidential and protected legal advice for the benefit of the firm in a way that's not then disclosable to the rest of the partners in an inappropriate sort of way. What are the other sort of really frustrating gaps that you find?
Well, connected with those kind of potentially serious partner misconduct issues are the process for dealing with that partner. So often you don't see disciplinary policies and grievance policies applying to partners. They might apply to employees, but there's nothing actually governing how you deal with an allegation against a specific partner. So ensuring that's in place is really important. And also provisions in the agreement that give the firm appropriate powers to actually sanction that partner if they are found guilty of any misconduct. Is again often missing. Sometimes firm will have compulsory expulsion provisions, which can only be activated in the most serious cases. So the partner might have done something that doesn't quite warrant expulsion, but there's nothing else to deal with that or sanction that partner other than expulsion. So you're kind of left with an extreme reaction. Yeah.
It's sort of like expulsion or nothing. You've got no other rights unless they're sort of negotiated effectively.
Yeah, so you might want to think about other different sanctions that you might want to apply, for example, impacting their partner remuneration, or maybe even moving them down a lockstep, or even de-equitizing them as alternative sanctions that you might want to apply. The kind of other crisis points that firms can often face is around cash and financial resilience. So having a number of protective measures in your LLP agreement can be really helpful to ensure financial resilience for the firm. So firstly, ensuring that you actually have in your partner reward policies provisions that actually reward partners in good financial hygiene, including cash collection, is really important. And then in terms of conserving cash, having the ability to actually reduce or withhold distributions in the event of there being a cash flow issue. So we obviously saw during COVID, in almost extreme situations, a situation where firms were facing an extremely uncertain economic environment, and where some firms didn't have the ability to withdraw or reduce cash distributions. That kind of was an extreme example when it was really sorely needed. We might see that again with basis period reform coming up, where firms will be again stretched for cash, whether they need to have the ability to manage that more carefully in their partnership deed is going to become another big focus.
It's really important to get ahead of that now.
Yeah,
sort of basis period reform, cash impact coming down the line.
The other point where firms can often find cash flow issues where there are a number of partners departing, whether it's succession hasn't been managed quite properly and there's a number of partners approaching retirement age, or if there's a team move, for example, and at that point the firm can have a big cash crunch because they have to repay capital, they have to pay any partner distributions owed to those partners. So having provisions in your agreement are like giving you some leeway to delay some of those distributions if you need to because of cash flow, or even having a more extended repayment period, especially for partners who might go off to a competitor. So more and more we're seeing provisions in LLP agreements differentiating between good and bad leavers, which means if somebody's going to a competitor and taking a team with them, you could repay their capital over and distributions over a much extended period. And again, that really helps the cash flow of the business.
And it helps focus potentially exiting partners' minds as well.
Absolutely.
So when firms are coming to you to ask you to sort of review their constitutional documents, what are the big reasons at the moment that you see them coming for that kind of review?
I certainly since COVID, obviously firms had some firms had really good financial years, and that's tailing off a little bit. So it's often to do with their kind of strategic review, following that kind of fairly good financial period over the last couple of years, going into a different economic uncertain period, I guess. And part of that is strategically looking at the partner remuneration structures and whether they remain appropriate. They may have outgrown some of those incentivization structures for their partners. They might have taken on a lot more partners over the last couple of years. So ensuring that the remuneration structure remains competitive in the market and incentivizes the right behaviors in partners and rewards high performers is really key. So often firms will come to us as part of that strategic review of their partnership reward structure, and while also looking at their partnership agreement as a whole. And again, as I mentioned before, the key kind of performance indicators around financial issues and other behaviours becomes really important. And firms are more and more not just looking at financial behaviours, but also other types of behaviours in terms of collaboration, in terms of good citizenship in the firm, being a role model within the firm, with the increased kind of focus on workplace culture, especially for regulated law firms, for example. We have lots of, guidance coming out of the Law Society around workplace culture, ensuring that partners have the right requirements in their LLP, duties in their LLP deed that require them to ensure that they're following their duties under regulation as well as the partnership deed is really key. And is more and more forming part of the reward structure of partnerships, I think.
So one of the other things we wanted to talk about was the new GC online tool, CheckYourLLPAgreement, which allows people to look at their own LLP agreement and kind of self-audit using the tool. It takes you through. Now, this is something that you've taken the lead on and worked very heavily on for the last couple of years. So this has been a real kind of labour of love. And hopefully you'll be able to see this tool. It takes you through a series of questions and it gives you a traffic light response with some commentary.
As you mentioned, it has been a bit of a labour of love, and it's based on really our extensive experience of advising many types of businesses, from global multinationals to founder-led firms, on their governance and decision-making and partnership deed provisions. And often the key gaps in protections that we often see in firm LLP deeds. And it covers everything from governance to remuneration issues to partner admissions and exits, and any kind of potential partner disputes that you might have. And so hopefully it should give people a really good kind of high-level overview of the key things that they should be thinking about in their LLP deed, and give them an idea as to whether they have the key protections that we would normally expect firms to have in order to have a resilient business and governance within their firm. So hopefully that should give people a good idea of the things they should be thinking about in their LLP deeds.
Right, so should we do just a quick flick through some of the initial questions? So let's say it's saying, has your LLP agreement got appropriate decision-making powers? So have you got delegated authority? And we're going to say, yes, we do have delegated authority for certain routine management decisions. We get a green for that. Do we have an option to hold members' meeting at short notice? Yep, we've got that too. We've got right to do written resolutions as well. Can we hold the meetings remotely by telephone or video? I think, no, I'm not sure we do. So then we get an amber and it tells us why that would be a good thing to have. And then it says, can we appoint a proxy? Yeah, we've got that. Can we exclude members to participate in decision making? So in this example, let's say, no, we don't. So then it gives us amber, that's not great. And it gives us an explanation as to why it's a useful thing to be able to do that. We then move on to allocation of profits and losses. And do we have the power to reduce a member's fixed share or profits or drawings on account profits? No, we don't. And then we come up with a red. So then it tells us why it would be really good to be able to include those powers when we are reviewing. And it takes you through to a glossary, etc. Does it have provisions around how capital profits are to be shared? A lot of firms' agreements miss that out, right?
Yeah.
And as more professional services firms become interested in capital value and disposal, that's an important thing to include. Power to demote? No, we don't have that. So it gives you an amber and feedback and some comments. So you go through all of these areas, and then it comes out at the end with traffic light based guidance and comments, which hopefully users will find helpful, and you can print it off. It is just guidance. That's right. It's not intended to be legal advice, but it is hopefully useful starting point for firms and sort of senior management, GCs, and advisors to them when they're considering, how to modernise their LLP agreement. So, thank you so much. Thank you, Zulon. An amazing job on that online tool. It's brilliant. If you're interested in using the tool, do get in touch. And also, if you've got any questions about how your LLP agreement could be modernised in sort of the current economic environment, again, please do get in touch. Zulon loves talking about these things. Also, our other partner, Corinne Staves, who's also a partnership structuring and partnership advisor, both of them very happy to discuss partnership issues and partnership LLP and structuring issues with you. If you need a Swiss verein created, or you need an ABS or an LLP converted, these are the advisors for you. So again, thanks so much, and have a great day. Take care. Bye-bye.
Bye-bye.